in the charge against them in count 1. It is not enough for purposes of the charge in count 1 to demonstrate alleged fraudulent roles that each person supposedly played in the subject procurement without tying it all up with a common intention to that end. That obligation does not belong to the accused but to the state, and therefore to go by the state's aforesaid submission would be tantamount to calling the accused to fill up the gaps in the prosecution case, which is not acceptable. In the end, I uphold the joint submission on behalf of the accused that the charge of conspiracy in count 1 against all the accused persons is not established on the evidence called. Consequently, the same is hereby dismissed. Now referring to count 5, and a signature by one Michael Orido, a director of the 13th accused, through letter of acceptance, Exhibit 126. As already earlier seen, Section 75 PDA of 05 envisages that those documents are the letter of award, is Exhibit 8 and 79, the LPO, Exhibit 104, and the written acceptance, Exhibit, the latter of which he equates to an LPO. It is, however, important to note that the charge in count 5 is not based on an alleged violation of these cited provisions. Section 68 of the PPDA 05 provides as follows: enter into a written contract based on the tender documents. Consequently, I find that count 5 against following orders. Number 1, all the accused in count 1 and the first accused in count 5 are hereby acquitted under Section 210 CPC. And number 2, a case is sufficiently made out against the 11th accused in count 2, the 13th accused, the 13th, 15th, and 16th accused in count 3, 4, and 7, and the 13th to 16th accused persons in count 6. And all those accused persons are called to their defense. Right to appeal within 14 days.